Good afternoon, and thank you so much for joining us today. I'm Steve Seepersod coming to you from the campus of Binghamton University, and on behalf of the Alumni Association, I would like to welcome you to today's program, Basics of Estate Planning, What You Need to Know and Why. This is part of the Binghamton Learning Network webinar series, which is something we offer on a regular basis, part of our lifelong learning program. It's just one of many things that we do here at the Alumni Association to connect with you with the university and with other alumni. I'm going to pull up the website address here on the bottom of the screen, binghamton.edu/alumni. Check us out after the show. Learn about all that we have to offer, lifelong learning programs, volunteer opportunities at the university, events, real in-person events and virtual events, and different ways that you can connect and enhance your personal, professional, and career development. Binghamton.edu/alumni. We are here to keep you connected to the university and other alumni. So on to today's program, and we are happy to take your questions. It was very exciting to see we had almost 200 people registered for today's event, and so we should have a lively chat, I am sure. So if you are watching us on Facebook or the microsite, you'll see there should be a comment box, and you can add your questions. Start now, start whenever you want. We will take these rather than waiting until the end. We can take your questions during the program. So go ahead and send those in. From time to time, I'll pop my email address on the bottom of the screen as well. And that's another way that we can take questions. So send them on. We want this to be interactive and fun. So on to the topic for today. Not exactly the most pleasant thing for many people to think about, planning for death or disability, but the effort that you put in and the thought you put in and what you do to plan for these unfortunate events before they happen. It really can be very, very helpful to you and to those who are very close to you when the time comes for things to happen. And so that basically is the thrust of today's event. And we have a speaker who is very well versed on these topics. I'm pleased to bring in Marc Bekerman from the class of 1989, an estate planning attorney, and teaches this topic on the university level based on Long Island. And he'll be giving a presentation here this afternoon and be happy to take your questions. So send them on in. Marc, thank you so much for joining us, and appreciate having you here on the webinar.
Thank you, Steve. I'm looking forward to hopefully giving everybody a little bit of information. I will say that although it's not the most pleasant topic, the fact of the matter is if you don't do it well, it doesn't mean you're not going to die. So don't think that by not doing the well, you're somehow preserving that opportunity to not die. So we're going to have slides up. Thank you, Steve. So again, this is just a brief overview of estate planning. I teach a full-time law between two law schools, and one of the seminars I teach at both law schools is estate planning. So obviously there's a lot to do here, and this is just more of an introductory lecture, maybe get you thinking about the right things for you. So when I talk about estate planning, I'm really talking about two different concepts. Most of my clients who come to me, they're ready to plan for death. And yes, estate planning is planning for death and a will, and we'll get into all of that. But what many of my clients aren't anticipating, and I bring to their attention, is that it's a good time to also plan for disability. I don't know what the current statistics are, but a certain percentage of people do become disabled before they die. And depending on the nature and extent of the disability, they may not be able to manage their own financial affairs. They may not be able to make medical decisions for themselves. So it's important, I think, when you're doing the planning for death portion of estate planning, that you also do the planning for disability portion. And if we're planning for disability, one of the concepts is to manage property. So for someone who, for whatever reason, isn't able to manage their own property, it could be a physical issue. It could be a mental disability, but for whatever reason, they need to have their property managed for them. So the form that we use, at least in New York, I think it's true in most jurisdictions, and we will be focusing on New York law here, if only because that's where I live, practice, etc. In order to manage property, there's something called a power of attorney. And the power of attorney, essentially, that the form is actually in many cases very simple because there's a form that was promulgated by the legislature. The legislature said, here's a form if you want to use it. And for most of my clients, the statutory form is sufficient to meet their needs. And what the power of attorney does is it designates an agent An agent is just the person who's going to be acting under the power of attorney to manage property and to manage personal affairs, with the exception of healthcare decisions. We're going to talk about healthcare decisions separately. So essentially, this is me saying I want my wife to be able to manage my property. I work with married couples, as you could imagine, quite a bit, and they'll say, oh, well, all our accounts are joint, which is true for my wife and me. But for example, my retirement account is in my name alone. A retirement account like a 401k can't be jointly owned. My wife is the designated beneficiary, which is great if I die, or really when I die, she will receive that. But what if I'm incapacitated? What if I'm in a coma? What if I have dementia? She would not be able to transact on my 401k simply because she's the designated beneficiary. So this can be a very important document, especially because I have a lot of clients where, for example, their retirement assets are a significant portion of their estate. The selection of agents is crucial. Whether you're having the person be able to manage the property while you're still competent, that is an option. Some of my clients take it. But certainly, since we're looking towards planning for disability, if I'm incapacitated, it's going to be hard for me to have my agent account to me. There are courts that can get involved and whatnot, but obviously we're trying to keep this simple. We're trying to keep courts out of it to the extent possible. So selecting agents is crucial. You want to make sure you have the right people. The other thing to consider is whether you want to have multiple agents versus successor agents. So for example, I have clients who, let's say they're widowed and they have 2 children. So do they want both children to act as agent? If so, do they have to act together, which can be clunky if, let's say, one child lives in California and one child lives in New York. If we say that they have to act together, that means that that child from California might have to be coming in to help manage property. Another alternative could be successor agents. You might have one agent being able to serve, let's say, the New York child, and if the New York child can't or won't serve, then the California child. So there are advantages and disadvantages to both, as you could imagine. What do you do if you have multiple agents and they have to act together and they can't agree? That's a problem. What if you have multiple agents that don't have to act together, but one does things that the other doesn't like? That could be a problem. So again, these are 2 significant points to consider, selecting the agents, and then if you're having multiple agents or successor agents. When should the power of attorney be effective? There's really 2 choices. You can have the power of attorney effective immediately, and very frequently my clients who are naming their spouse want it effective immediately, and I have no problem with my wife having a power of attorney for me. The other option, at least under New York law, is something called a springing power of attorney. It's not effective immediately. It becomes effective at some future time. And the question is, what is the trigger? I usually recommend to my clients to leave the statutory language, which allows any doctor who has examined you in the last, I think it's 18 months, to certify that you're incapable of managing your own affairs. There can be some tricky things with springing powers of attorney, but I see that more when parents are naming the children. So in other words, I might say my wife has the power of attorney effective immediately, but if she can't or won't serve, I have twins, it's my twins. They have to act together, but they only get to act if I am incapacitated. I don't want them using the power of attorney as long as I can manage my own affairs. Those are your 2 choices. I would caution if there's any Florida people on the line. Florida does not accept springing powers. They have something else. I think it's called standby guardianship. I'm not admitted in Florida, so I don't give Florida advice, and I don't really know Florida law. So I would defer that if you are in Florida, that you should seek legal counsel in Florida with regards to powers of attorney. And again, one of the things with powers of attorney, certainly in New York law, is you must have a statement in the power of attorney that the power of attorney survives the principal, that's the person who's signing it, their incapacity, if that's what they intend. So for estate planning purposes, we're basically doing the power of attorney for the incapacity. So the powers of attorney that I do for my clients in estate planning are always what we call durable powers of attorney, in that the power of attorney states that this power of attorney shall survive the incapacity of the principal. The other thing some of you may have experience with or seen, you can have a power of attorney for a specific purpose. So for example, you could have a power of attorney. I did this as a favor to a client, and they say the road to hell is paved with good intentions. A client at the beginning of COVID was stuck overseas, and he needed to close his a real estate transaction. And they said that they would allow someone to do it with a power of attorney. He asked, would I do it as his attorney? Would he could, he could give me a power of attorney. So I went to the real estate closing, and I basically signed my name as his agent about 100 times. But that was only for a specific purpose. I could not do anything else with that power of attorney other than close that specific real estate transaction. Some of you may have financial accounts where you've given a power of attorney to your financial advisor. For example, if it's a purely discretionary account and you don't want them to have to clear every trade with you, there are clients that give their financial advisor a power of attorney. But again, it only relates to that account. You're not going to let them sell your house for you if they're your investment advisor.
Mark, I'll jump in with a question that we have taken from one of the audience members. So great to see those coming in already. What if you do not have people to serve as agents? How do you find people who can do that?
That's a great question, and that's a complicated question because it's true throughout all of estate planning. I have clients that's the biggest struggle. They know everything they want, but they don't know who they want to serve in roles. So powers of attorney, you want to name somebody who you trust. It does not need to be a family member. It does not need to be your closest family member. So if you have anyone in your life that you would trust and who's willing, because that's the other thing, is they have to be willing to do it. And I have friends that, quite frankly, if they asked me to manage their financial affairs, if they were to become incapacitated, I'd say no thank you. So you need to find someone who's willing to do it. If you can't find someone who's willing to do it, you can kind of plan for disability for property another way, which is using a revocable trust. It's a little outside the scope here, but there you would be choosing someone to be trustee, and that might make more sense depending on who you're looking to have do it. The other thing is, if you have enough assets, certainly you can get a bank or a trust company to act as the trustee of your revocable trust, as opposed to they may not be willing to act as an agent under a power of attorney. So, but it's an excellent question. Unfortunately, for my clients that are in that position, there's not usually an easy answer, and we kind of find a way around it, either by finding someone or by using a revocable trust. So moving on for estate planning for disability, again, we had mentioned that the power of attorney does not allow the agent to make medical decisions, at least not under New York law. Other jurisdictions have other rules. So in New York, if you wanted to name someone or designate someone to make decisions for you, medical decisions, we use something called a healthcare proxy. And the healthcare proxy, we designate an agent to make medical decisions in case the client, the principal, is unable to make decisions. So I always tell clients, you have the right to make your medical decisions as long as you are able to make your medical decisions. So even if you sign a healthcare proxy today, it will not give someone the ability to make medical decisions for you unless you are incapable of making those decisions. And when I say incapable, I don't mean that you're waffling. Incapable means you do not have the mental capacity, the decision-making capacity to make that decision. Sometimes it's very clear someone doesn't have the capacity, and sometimes, a hospital might bring in a psychologist to try and assess whether a patient has the capacity to, let's say, consent to a treatment or to refuse treatment or to leave a facility against medical advice. But again, this is crucial, because this is going to become effective. Unlike a power of attorney, which may be effective immediately, et cetera, this is going to be crucial, because this proxy, although you sign it now, it really only becomes effective once you can no longer supervise the agent. So selection of agents is crucial. I always tell the story of my parents. My parents were married almost 50 years before my dad passed, and they differed on one big thing in life, and we'll get into living wills in a couple of slides. But my father believed where there was life, there was hope. And when my mother believes quality of life, not quantity of years. So my mother did not have my father as her healthcare agent, because my mother was concerned that my father would not honor her wishes and have the proverbial plug pulled if circumstances called for it. My mother was my father's healthcare agent, and my dad was very sick for many years, and I would be in the hospital occasionally with them when the doctor would come in. And although my father had capacity up until about the last week of his life, he had a stroke and he never regained consciousness. So it was clear he didn't have capacity that last week. Prior to that, he had capacity. And the doctors would come in and they would ask him a question. And my father had capacity. So even though my mother had the healthcare proxy, it was my father's decision. Now, having said that, I think one of the secrets to their long, happy marriage was I never saw my father make a medical decision without looking at my mother and saying, "What do you think, hon?" And then whatever my mother said, my father went along with. So it was his decision, but you do have the right to ask people, whether they're healthcare agent or not, what their suggestion might be as far as, should I do this treatment? Should I not do this treatment? But the healthcare proxy itself only applies once you are unable to make these decisions for yourself. So again, selection of agents is crucial. And again, do you want to have multiple agents versus successor agents? And it's the same issues that I mentioned when we talked about the powers of attorney a few minutes ago. For example, if you have multiple agents, what happens if one person wants to pull the plug and the other wants to try exploratory surgery? The idea behind these documents is to avoid having to go to court. So you might have that issue. And again, so multiple agents have issues, and then successor agents. If you want, you can do people like this one, and then if that one can't do it, someone else, and so on and so forth. But with all the things we're talking about, power of attorney, healthcare proxy, it's crucial to make sure your agents are willing to act, because I have had a couple of times that I always tell clients, make sure, and then you find out the agent isn't willing to act. Now, maybe they were willing to act back when the document was done, but sometimes, like, I would have never said yes. I only hear later.
I'll jump in with another question that has come by email. If you can't name your beneficiaries as your power of attorney agent, I guess it's a conflict of interest, question mark, who can you name as an agent? And a second question, which I guess maybe we'll come to later, but it's totally up to you. Please recommend a good way to find an estate planning lawyer.
Okay, so let me handle the first one first, and if it's okay, we'll defer the last one to later in the program. You can name a beneficiary as your agent under any of these things. The agent owes what we call fiduciary obligations, certain duties to the principal. There's a seminal case out there, matter of Ferrara, which I wouldn't expect any of you to know. But essentially, just because, let's say I was my mother's agent and I'm my mother's beneficiary, I still can't steal her money. I still have to do what she would want me to do. All of these things, powers of attorney, healthcare proxies, you're supposed to do what the principal, what the person signing the document wants you to do. So absolutely, you can name your beneficiary as agent. If you think it's a problem, then that's a different discussion. But there's nothing in the law that says they cannot act as your agent. And if they choose to act as your agent, if they agree to, then they're bound by these fiduciary duties and obligations to do things in accordance with your wishes and your directions, which may or may not be consistent with their wishes. And it's actually a great bridge, because one of the things when I draft a healthcare proxy, for a healthcare proxy, the agent has to make decisions which would be consistent with the wishes of our principal, the person signing the document. So where does that put us? Well, sometimes if it's crucial enough, put it in the document. Say, I want artificial nutrition and hydration, or I don't want artificial nutrition and hydration. Understanding that once you put it in the document, it's likely going to be binding, even if you change your mind later. So it's one thing to be kind of vague about what you want and just have a conversation with the people. But if you feel strongly enough to put it in the document, should you change your mind later, you probably should update your documents at that point, because otherwise people are going to say, well, yeah, the healthcare proxy is 15 years old, but this is the stated intent, and the agent can't go against the stated intent of the principal. Within healthcare proxies, in order to make these medical decisions, many of you have probably run into HIPAA. HIPAA is, doctors get very scared because the potential penalties for violating the HIPAA rules are significant. So you want to make sure that a healthcare proxy addresses HIPAA privacy rules. You never want to have a situation where the doctor says, yes, you have a healthcare proxy and you can make decisions on behalf of your principal. That's the way it might be phrased. But I'm not authorized to give you the information to make those decisions. I mean, that's like the worst of all worlds. So, for instance, in my healthcare proxies, I have a full HIPAA release, a paragraph just with HIPAA release language to ensure that my agents will be able to get the information necessary to make the decisions. So that's also something important to look for. Related to healthcare proxies and making medical decisions are living wills. New York law assumes a person wants to live. And living wills are usually declarations to die. So if I have a client like my father who believe where there's life, there's hope, keep me on the machines, and etc., we don't do a living will for them. When I have clients who have certain things they wouldn't want done, or they don't want a lot of things done, that's when we first break in living wills. Again, you sometimes it's good to be talking generalities and vagaries, because if you say certain things specifically, that will bind everybody later, and that may or may not be consistent with your wishes at a later time. It doesn't mean you can't update the documents, but if you don't update the documents, we're looking at an old document that may or may not reflect your current wishes. So living wills are important for people like my mother, who believe quality of life, not quantity of years. And what they usually do is they say, and again, keeping in mind, if you are competent, you have a right to have treatment withheld, you have a right to have treatment withdrawn, you have a right to refuse treatment. This really is, again, coming in if someone is incapacitated, and whether there's a healthcare proxy that names an agent, whether someone is making decisions under some law or statute in the absence of a healthcare proxy. The idea here is we are letting, through the living will, let the decision maker know this is the client's, this is the principal's intent, this is the patient's intent, and they are expected to follow that intent. So again, someone like my father, my father didn't have a living will because he wanted, all sorts of measures taken. And someone like my mother has had a living will since even before New York law may have even recognized them. So again, this is an important document. I've seen living wills incorporated into the healthcare proxy. I tend to do two separate documents, but I have living will language in the healthcare proxy. If you're doing two separate documents, the living will doesn't name somebody, it just sets forth the intent. So if those of you who are online remember Grey's Anatomy, Mark Sloan had a living will that basically said, if I don't wake up for 30 days, withdraw my treatment, and that's what they did. Always love getting my pop culture references in.
I have a few questions that have come in, so that's always good to see. And we'll take these back to back. The first one is, are there any outside groups or government entities that keep track of what a healthcare or financial proxy actually does in fulfilling their duties?
So typically a healthcare agent or an agent under a power of attorney, there's no independent thing necessarily looking at them. If there's a concern that someone is not acting appropriately under one of these documents, in New York, we have a New York State Supreme Court. You can generally, someone who is interested, and that's defined in the statute, and I don't want to go too far sideways on that, but ultimately a court can invalidate a healthcare proxy and or a power of attorney if the agent is exceeding the scope of their authority, acting inappropriately, or not in accordance with the proven wishes of the principal. That's usually done in the context of a guardianship pursuant to Article 81 of the Mental Hygiene Law, and that could probably be its own lecture that if Steve wants, we could do another time. But that's kind of the check and balance, is to have someone who's interested in the welfare, which could be anyone from the facility to family members, maybe even, I don't know, all friends, but the statute is pretty expansive who can bring a proceeding under Article 81. And then in Article 81, the judge can appoint someone who's not the named agent, and then as part of the Article 81, rescind the power of attorney in the healthcare proxy if they feel there's just cause to do so.
The next question is, what if you have no living relatives who can serve as, and this is written as HCPOA. So to me, it's not clear if it's, okay, yeah.
I assume that's the healthcare agent. So again, it doesn't need to be a relative. It could be anyone who's over 18. They have to be over 18 because anyone under 18 can't make their own decisions. Anyone over 18, and just someone that you trust would do what you want them to do under circumstances where you're unable to express your wishes, make your own decisions.
We'll take one more, then we'll move on. But I was thinking, yes, that was part of what was shared earlier, is that it need not be family, just as long as you can trust the person to do what you want. That's the most important thing. The next question, is there a minimum wealth amount or value that one should have before even bothering with living wills or revocable trusts?
So living wills have nothing to do with the value of your estate. A living will is just you setting forth what kind of treatment you do or don't want under certain circumstances. So it's completely unrelated to wealth. I'll address, if it was meant to say last will, like last will and testament. Most people should have a will. If you have no money but you have minor children, and we'll talk more about this in the back half of the presentation, If you have minor children, you should have a will, regardless of your wealth. As far as revocable trusts, depending on the attorney, some attorneys feel revocable trusts should be done by everybody who's doing a will, and some attorneys only pick and choose the circumstances when you should use a revocable trust. So part of that is going to depend on the person you're using to do your estate planning and how they feel your affairs should be sorted out, should be set up.
I lied. Before I put the slides up, you get me again with another question. This one is, what if you have these documents, but they are not honored? I have a neighbor who has a DNR, no life-saving treatment, but was administered treatment. Basically, how do med professionals know? Do you always have to have the document on you at all times for proof?
Yeah, it's a great question. And the fact is, I've had that happen with patients. Depending on, if someone is very sick and going to the same hospital frequently, it should just be on file with the hospital. I had a client who it was on file with the hospital, but the EMTs didn't know, so they administered it in the ambulance. I know somebody who has posted their DNR over their refrigerator because somebody told them that that's where the paramedics look, is over your refrigerator to see if there's any DNRs or whatnot. For better or worse, I'm not sure what the remedy is if you have documents that the facility is not aware of, so they act in contradiction to those documents. At the same time, if they are aware of the documents and they're refusing to honor it, in theory, somebody can go to court and get an order to get, let's say, the hospital to honor the documents that were done. But, obviously this is big and clunky and, not a good scenario for anyone, but you're still better off having the documents than not having the documents. So coming back to the slide deck, we do now come up to planning for death. So again, that was a good bridge when we said we will talk in the back half about planning for death. So, the basic question I think people will ask, whether they ask me or they ask themselves, is what if I don't have a will? More people still die without a will. We call it intestate in the field. More people still die without a will than die with a will. And, the first thing to remember is if you don't have a will, you're still going to die at some point. So what's going to happen when you die? Well, first of all, New York law is going to determine your beneficiaries. So the assets that are in your name that you own, other than a spouse, only blood relatives can inherit if no will. So if you're really close with a friend, they cannot inherit through what we call the law of intestacy. If you are very fond of your sister-in-law or your brother-in-law, they cannot inherit through intestacy. If you're fond of your stepchild, they cannot inherit through intestacy. Other than a spouse, usually only blood relatives can inherit in the absence of a will, and we look to the closest relatives. So the first level is spouses and children. If you have a spouse, if you have children, if you have one and not the other, that's where the money will go. If you have no spouse and children, it would go to your parents, and if not your parents, your siblings, and if not your siblings, your grandparents, and then your aunts and uncles and cousins. It gets a little detailed, the statute, but essentially we reward the closest relatives if you die intestate. Now, who's in charge of the estate? If someone dies without a will, who's going to be in charge of collecting the assets and paying the claims and filing the tax returns and all that kind of stuff? We call that an administrator. Some of you may know that in a will, it's called an executor. Without a will, it's called an administrator. Typically, it's the closest relative. So, for example, if you die with a spouse, they will typically have the first chance to be the administrator. If you have children, it will be the children. But you can have issues. So, for example, one issue is, what if your closest relatives are your cousins on your father's side, your paternal first cousins? That could be a problem for the court. They may have to prove their status, and there may be some statutory issues. What if you have multiple people with the same relationship wish to serve? You have, someone has 3 children, and each child wants to be the administrator. So the court has to figure out, if you have a will, you get to choose who your executor is going to be. But in the absence of a will, the court says, right, the children have priority to everyone but a spouse. Let's say there's no spouse. I've got 3 children, each of whom want to be the administrator. The judge has to pick among the 3. Sometimes we'll have 2 versus 1, and the court will tend to appoint the one that's supported by 2 versus 1, but that's all discretionary with the surrogate. And then finally, as far as who can be fiduciary in the absence of a will, New York law, the Estates, Powers, and Trust Law, Article 11, if anyone cares, determines what powers that fiduciary will have. And when I do a will, I not only give all the powers under New York law, which is automatic, by the way, even if I don't put it in the will, if assuming that the executor serves in New York, but I give powers to an executor often that aren't included in the default New York provisions, which wouldn't be available in an intestate estate when somebody dies without a will. So if now people said, all right, I don't want the legislature choosing my beneficiaries, I don't want the legislature choosing my fiduciary, I don't want the legislature deciding what powers my fiduciary does or doesn't have. Okay, I want a will. But what does a will do? Well, one of the basic things a will does, it disposes of property. And one of the things I want to address now is what kind of property. So one of the things that's very important is the idea of probate property versus non-probate property. Probate property is disposed of either through intestacy if there is no will. Probate property is disposed of under the will if there is a will. What is probate property? And I didn't do a slide on this, I don't think, so I do want to bring it up because it is an important concept. The probate property is simply property in your name with no named beneficiary. So, for example, when my father passed away, he had a will, but he had no probate property. The condominium that my parents lived in was jointly owned by my parents, so my mother automatically inherited that when my father passed away. So joint property with right of survivorship goes to the surviving joint owner. Similarly, they had a bank account, which my mother inherited when my father died, regardless of what his will said. The will left everything to her anyway, but we didn't even need the will because the surviving joint owner gets the joint property. My father had a retirement account. And for those of you that have retirement accounts, you may recall when you opened it, you designated a beneficiary. My mother was the designated beneficiary of my father's retirement account. So again, the will didn't come into play. My mother inherited the retirement account as the designated beneficiary. And finally, my father had life insurance, and my mother was the designated beneficiary. So my father had two things in his name with my mother as the designated beneficiary. He had two assets that my mother was the joint owner of. And so when my father died, my mother inherited all of those things. And so his will, we didn't even have to bring his will to the probate court, to the surrogates court. So, but to the extent we have probate property, so this is property in somebody's name without a named beneficiary, we're going to dispose of that property in the will. So what kind of gifts are there? Well, you can give away real estate. You can give away personal property. A lot of times that's tangible personal property. That's the stuff people have. So it might be the contents of their house or their apartment. It could be their car. It could be a stamp collection. So we often give away real estate. We give away personal property, which is often tangible personal property. Clients will make cash gifts. They'll say, I give, $5,000 to this person. I give $10,000 to Binghamton University, whatever it is. Cash gifts, what this sounds like. They just give cash off the top. And then whatever's left over is what we call the residuary gift. Most of the time, the residuary is given to the person or persons or entities that the client wants to benefit the most. In other words, so I might have a will that says I give $1,000 to each of my nephews, and then everything else goes to my wife if she survives me, and if she doesn't survive me, then to my children. These gifts can be made outright or in trust. And a lot of times, whether we use a trust is a question of what is the type of gift in terms of the nature of the gift. So, for instance, tangible personal property doesn't work well in a trust usually. What's the value of the gift? It probably doesn't pay to create a trust if you want to give $1,000 to your nephew, like I just said. Are there concerns if it's a large amount? Can the beneficiary handle it? Even if they're an adult, can the beneficiary handle it? And then, of course, there may be tax implications and whatnot. So this is kind of a very large issue, whether the gift should be outright or in trust in some circumstances. And that's going to depend very much on the client's circumstances. What else do we do in a will? We appoint fiduciaries. So every will should, I can't say every will does, every will should appoint an executor. That's the person who's going to be in charge of the estate. So without a will, we call it an administrator. With a will, we call it an executor. And they're the ones who are in charge of basically wrapping things up. They identify the decedent's assets. They collect the decedent's assets. They pay whatever claims there are against the estate. They file tax returns if there are tax returns to be filed. They satisfy the gifts and basically wind up the estate when the estate is ready to be wound up. So the executor is the person in charge of, if you want to call it administering, some people call it settling the decedent's estate. If the will creates trusts, the will should also name a trustee. The executor may be different than the trustee. Plenty of times, depending on who the beneficiaries are, I might have an executor be, let's say, the surviving spouse, but if there's a trust for grandchildren, it might be that the child who's the connection to the grandchild is the trustee of the trust. So you have executors in every will, you have trustees if you create a trust under the will, and then you have guardians. You should certainly be naming a guardian if there are minor children. There's a different discussion to be had if you can or should be naming a guardian if you just have a disabled child. But if a child is an infant, in other words, if they are under 18, you should name a guardian, because someone's going to have to, take the kid in and raise the kid. And if you at least want to name somebody, that will give the court something to start with. The court will always do what's in the best interest of the child. Let me just say that. But if you don't name a guardian, either one, maybe there are no one comes forward, and then what does the court do? Or maybe it's an embarrassment of riches, and 5 family members all say, I want to raise the kids, and then the court's got to decide. So it's better that you give guidance and say, I want my sister, or I want my brother, or I want my best friend, as opposed to I want my parents or something like that. The guardianship, I've had estate planning clients where things got tied up for extended periods of time because the husband and wife I was working with couldn't agree on who the guardian would be for the minor children. And then we give powers to fiduciaries. I mentioned before, we can expand local law, which is I often do in my wills. You can limit local law if there's a reason to do so. I don't do it frequently. I can't remember the last time I did, but it does come up occasionally. You can provide for certain powers even if somebody moves, because my clients don't agree to die domiciled in New York. So if they move to another state and they die in the other state and the fiduciary is appointed in the other state, generally they would get the powers under the law of the state where the person died, where the fiduciary is appointed. But I will sometimes, depends on facts and circumstances, say something like, my fiduciary shall have the power of all states where they shall serve and the state of New York, or something like that, to make sure I get the New York powers in as well. So that's one way you can provide for certain powers if the domicile changes. And then some people just put a laundry list of powers into the will itself. A lot of people do ask me about estate and gift tax. I'm not going to get into any politics on this. There is certainly political stuff that goes on about this, but just to give you some ideas. For decedents who die in 2023, their lifetime exemption of estate and gift tax for estate and gift tax purposes is $12,920,000. So if you make no gifts during your lifetime that reduce that, and we'll get to the annual gifts in a moment, but assume for a moment you, like most people, have not given taxable gifts during your lifetime. Someone who dies this year has almost $13 million of exemption if they're a U.S. citizen. Most of us do not die with $13 million, so most of us do not have to worry at all about the federal estate and gift tax. Let me just skip to the New York State estate tax, and then I'll come back to the gift tax exclusion. The New York, for those of you that live in New York, the New York State estate tax exemption this year is $6,580,000. So it's roughly half of the federal, but it's still a large number. If you don't live in New York, but you have property here, you may also be subject to the New York State estate tax, but that's way outside the scope of this discussion. I would just advise you that you work with your advisors to plan for that property if you can, if there's something that can be done. I would note that the federal estate and gift tax exemption, it doubled in 2017 under the 2017 Tax Act. It's scheduled to sunset in a couple of years, where whatever the numbers, it's increased every year by inflation. That's why we have these funky numbers. Whatever it is, it'll be cut in half unless Congress does something, and who knows whether Congress will do something or not. I'm not going to get political on that. So right now it's a big number, but it could be half that in a couple of years, which would make it roughly equivalent to the New York exemption, which is still, quite frankly, $6 million. Most people don't die with $6 million. Now, I'd mentioned something about if you've made taxable gifts during your lifetime. So I can give per donee, in other words, per person, I can give $17,000 a year. So when I teach this live, I say to my students, I might have 15 students in the room. I can give each of you $17,000. I don't even have to file a tax return. That would not reduce my lifetime exemption. So keep in mind that most people don't make gifts of $17,000 in a given year to a particular donee. And again, if it's per donee, so it's $17,000 to each person. Now I can't give $16,000 to one and $18,000 to the other. So if I do that, I'm using $1,000 of my lifetime exemption for the $18,000 gift. Now, there are a couple of potentially big deals that don't even count on this. Namely, if you make certain transfers for education and medical expenses, and this can get a little complicated and again, kind of outside the scope of this discussion, but the point I want to make is if you have a child who goes to Binghamton and you have to pay $20,000 a year for Binghamton, 25, I think it's probably a little over 25 now. The exclusion is $17,000. And you might say, oh, do I have to pay gift tax? And the answer is no, because certain transfers for education, I don't want to get into the weeds on this, but for instance, tuition is not, if you pay your child's tuition directly to the school, it is not considered a gift for gift tax purposes. If you pay medical expenses for someone directly to the provider, it is not considered a gift for gift tax purposes. So I have clients that transfer potentially hundreds of thousands of dollars a year to various family members by paying appropriate education and medical expenses. And when I say appropriate, I mean ones that under the gift tax rules are not considered gifts for gift tax purposes. So again, I mean, I've never made $17,000 in gifts unless you count. My son went to Cornell, which, he doesn't belong, I guess. My wife, my daughter, and I are all Binghamton alums. But my son went to Cornell, and yeah, I was paying Cornell a lot of money, but it was, most of it was under this gift tax exclusion. So I didn't have to worry about it. When we talk about estate tax, I do want to point out, just again, because I don't know who's on the line, and I don't want to shortchange this, while at the same time, I don't want to spend too much time on it. When we talk about the estate tax, it includes assets in your own name, it includes assets in joint name, and includes assets with a named beneficiary. The estate tax base is fairly comprehensive. So like I mentioned, my dad, we didn't have to bring his will to the surrogates court, but all of the assets I mentioned before would have been part of his estate for estate tax purposes, but he didn't have $6 million when he died, so we didn't have to file a New York estate tax return. So if you have a decedent who owns a house, an IRA with a named beneficiary, and a life insurance policy, which is not an infrequent thing, at least in my practice, they could have estate tax liability, and certainly New York estate tax liability, because of the available exemption amount. I'm not saying it's likely, it is possible. I have many clients who are worth between $6 and $13 million. And a lot of times the wealth is a combination of they bought the house in Long Island 40 years ago. They have a retirement plan that they've been saving for 40 years, and they hit a good stock market, and they have, $1 million, $2 million, maybe $3 million in life insurance. So there's planning that could be done. But again, if they just own this stuff, it's all part of the estate for estate tax purposes and subject to the estate tax. We do
I'll jump in. I'm sorry, before
yeah.
we go on to the next things, we have a few questions. I know you have a couple more slides to get to, and for those that want to hear all the information and get their own questions in, we had advertised 1 o'clock as the wrap-up time. We will go past 1. It's not a hard stop on our end, so don't worry. We'll get to the things that you want to know about. So one of the questions is, can I safely assume that the language in the signature of witnesses section on the power of attorney form, by signing as a witness, I acknowledge that the principal signed the power of attorney in my presence, in the presence of the other witness, or that the principal acknowledged to me that the principal's signature was affixed by him or her at his or her discretion, means the form can be signed and sworn, then the witnesses can together or separately sign after?
I don't go down what could do. I always have everybody sign everything together, because very often I'm doing a will with the power of attorney and the healthcare proxy. And what I do is I just have one big meeting and we sign everything all at the same table. The signature rules regarding the power of attorney are relatively new. They came in the summer of 2021. So I don't know of any case law on the point, but again, when it comes to estate planning, I don't like to take chances. So I just have, I have my client, I have the witnesses, and we all sign everything while we're all sitting at the same table. I don't know what if the question is, what can you get away with type of thing, as far as, based on the language, I don't have an answer, because I'm not aware of any case law, since that part of the general obligations law where the power of attorney is found is relatively new, and it's not my practice. My practice is to just have everybody sign while we're all sitting there, so there is no question.
And one more thing before we go back to the slide deck, do you list funeral wishes, cremation, etc. in your will? And if not, then where does that happen?
So I never listed in a will because the will is not offered for probate until long after your funeral is gone. Because in order to file a will for probate, you need a death certificate. You don't get the death certificate until after the funeral. So it's kind of clunky. There is a document which I don't think I went into in the slide deck because I'd say maybe a quarter to I don't think half my clients. There's a document which is allowed called an appointment of agent to dispose of remains. It's allowed by, I think it's the public health law in New York. And again, it came into the law 15, 20 years ago. And there's reasons for it, which I won't go into just in the interest of time, but suffice it to say, you can, in this document, which is called an appointment of agent to dispose of remains, you can designate the person who is in charge of your funeral arrangements, and you can give specific funeral arrangements. The weakness of putting your funeral arrangements in your will is your will not be accepted as valid by the courts in New York until long after your funeral has taken place. And so the question is, if your funeral says, I want to be buried, next to my wife, let's say, and your kids cremate you, it's a little late. So for my clients that feel strongly, I will do an appointment of agent to dispose of remains form for them. Steve, should I continue on the slides?
Yes, we can keep moving on for now. I'll put my email address back up, so if anybody wants to send a question, they can. Certainly the comment boxes are open as well, and we'll just keep moving along.
Okay. So again, little mini estate and gift tax lesson, I suppose. We have the gross estate, which I described on the prior slide. Basically, it's everything you own, including things that you own jointly or things with a named beneficiary. And then there are deductions for these things: funeral expenses of administering an estate, the debts of the decedent, most gifts to charity, and most gifts to a surviving spouse. It gets a little technical. If you give it to the charity outright, it's fine. If you give it to the surviving spouse, it depends if they're a citizen or not. And if you start using trust, then there's various rules that need to be complied with, again, kind of outside the scope of our 1 hour discussion today. Because of the available exemptions and deductions, a married couple can usually defer payment of any estate tax until the death of the second spouse. A very frequent form of estate planning is to use that available exemption, whether we're looking at the $6.5 million for New York, which is what I tend to deal with. I have friends that work in jurisdictions that there is no estate tax, so they're working more with the $13 million federal estate tax exemption, almost $13 million. So with some careful planning, with some, I don't want to say it's basic, but at the same time, it's not super complicated if you understand what's going on. So with some careful planning, if I have a married couple in New York, we can do $13 million free of the New York estate tax, which most married couples are not dying with $13 million in assets. So with some careful planning, even wealthy families need not be subject to the New York estate tax. And again, the federal exemptions are even higher at this point. So I usually start worrying about estate taxes for a married couple when they hit around 10 to 12 million, because I want to leave some room for growth in. But if I have a married couple that comes to me that's worth $5 million, at that point, I'm not really worried about the New York estate tax or the federal estate tax. Just again, for those of you that will either go see an advisor or have seen advisors, some of the ideas that we do for estate tax planning, we do what's called a credit shelter trust. For a lot of my clients, what we'll do is we'll set up a trust, and most of my clients will have very similar wills to each other. So on the death of the first, we're going to put money in a special trust called a credit shelter trust, the goal of which is to use the exemption that the first spouse to die has. Let's say that's $6.5 million. That gets a little more technical, and it's kind of outside the scope of our discussion here. Lifetime gifts are great. Remember I said you could give $17,000 per donee? Well, if you're married, you can give $34,000 per donee. And if you have a big family, you can give lots and lots and lots. I was at a firm 20 years ago. My boss had a client who, between the children's spouses, the grandchildren's spouses, and the great-grandchildren, he had over 100 family members. Now, back then, the exemption was low. The annual exclusion was lower, so let's say it was $10,000. So he and his wife could give $20,000 to each of these over 100 people. And it was funny. We would move a lot of money out using that technique, but he was very successful. And we would move $2-3 million out in a year, and you'd find out the following year it was like trying to fight waves on the beach. That but his net worth went up by $5 million. So what do we do? If you have life insurance, you may want to consider a life insurance trust. Again, you may be working with a life insurance broker. You may be working with a financial advisor. You might be working with an estate planning attorney. Life insurance trusts are a technique that might be able to move those life insurance policies out of your estate for tax purposes, but they may bring in other complications. And then, for I'll say very wealthy families that do have estate tax concerns, whether they're federal estate tax or New York estate tax, you can start talking about things like family trusts. Sometimes they're called dynasty trusts. Sometimes it's family trust. You can do something called a grant or retained annuity trust. You can do a sale to the family trust. You can do a qualified personal residence trust. There's tons and tons of techniques. But again, if it's being driven by tax considerations, you probably have, if you're married, you probably have 8-digit wealth. And I mean 8 digits before the decimal point. In other words, you're probably worth 10 million or more under current tax law. Tax law can always change. They could take the exemption down to 1 million. That was one of the things that was talked about when President Biden was running, was would the estate tax be taken back down, not to half as scheduled in a few years, but take it all the way down to like 1 million or 5 million or 3.5 million. I don't pretend to know what the future of the tax code is going to be. But if you have significant assets, if you've got 10 million plus, you should be talking to your advisor about how to, is estate tax a concern? And if so, what steps are available? Because some of the steps that are available, you may not want to take. So what's available for me to do to try and minimize the estate tax? Because what I've had clients that I've said, look, you never pay estate tax because the estate tax is due 9 months after you die. Your beneficiaries, whether it's your family, whether it's your friends, whoever your beneficiaries are, they are the ones who pay estate tax. So I was speaking with a prospective new client earlier today, and it's him, his wife, and he has a sister. Neither he nor his sister have any kids. And so I said to him, I wouldn't go crazy worrying about tax planning, because why are you going to take any steps to save money for who? There's enough money for you, your wife, and your sister. And, he hasn't figured out, and his sister hasn't figured out, and his wife hasn't figured out who's coming next. I said, once you figure out who's coming next, maybe we have a discussion. But off the top of my head, if you don't have close family that you're leaving it to, why should you spend the time and money now and inconvenience yourself? You can't just have it in your own name. You have to do things. Why bother doing it if, why are you taking steps to save the estate tax? I guess is what it comes down to. I do want to spend a moment on charitable gifts. As I mentioned earlier, charitable gifts may be a way to have a deduction for estate tax purposes. If you give it outright to the charity, it's just an outright gift. So I give to Binghamton University, and I think technically you're supposed to give to the foundation, but I'll get to that in a second. You can make a charitable gift outright, or you can do it through a trust. If you're doing it through a trust, it means that either you're going to have the charity get the trust at some time in the future, whatever's left over. That's called a charitable remainder trust. So you might want to provide something for other beneficiaries, for non-charitable beneficiaries like a spouse or children. So those are called charitable remainder trusts, that once the trust is created, when, let's say, again, if it could be created when you're alive, it could be created in your will. If you're creating while you're alive, you can keep that charitable interest, the non-charitable interest. But the idea is, with the charitable remainder trust, the charity is going to get the money at some point in the future. And there can be some very good tax reasons to do this. Again, I would check with your own advisors on this, and I'm sure the charities are often willing to help. I know that Binghamton has a great team that works with donors and prospective donors. Sometimes you want the charity to get the money up first, and then, after a period of years, whatever's left in the trust will go to the non-charitable beneficiaries. Those are called charitable lead trusts. So again, outright is one technique. Trusts are another. If you're using a trust, depending why you're using a trust, you may want to do a charitable remainder trust or a charitable lead trust. If you're making certainly any significant gifts, but even if you're making a relatively minor gift, make sure the charity knows about the gift. If you're making, especially if you're making a gift in the will, as I said, I teach this stuff at 2 law schools, and I teach cases where it was not made clear which charity was intended, because sometimes charities have very similar names. So make sure the charity knows about the gift. They may recognize you during your lifetime before the gift is made. So if you give money now, they can recognize you now. But even if you say, I'm going to make a gift to Binghamton University in my will, the university may have ways of recognizing that even before you pass away. Also, the charity can assist you in making sure the gift is made appropriately. I mentioned before, I think technically, and you can always speak to the foundation people about this and their great staff. If I were to make a significant gift to Binghamton, I shouldn't be writing it to Binghamton University anymore, since my daughter's no longer a student, and rather I should make it to the Binghamton University Foundation or something like that. So, especially if you're making large gifts, it's really good to kind of touch base with the charity, make sure they know about it, make sure you're giving it to the correct organization, the correctly named organization. Because the other thing is, especially if you're making a gift in your will, you can help guide how the gift will be used after your death. Maybe you don't care, or even if you're giving it while you're alive, maybe you don't care how it's used. Maybe you're making a gift to Binghamton to just be used for whatever the school thinks they need. We also have been fortunate. We've had donors that have had very specific ideas on how they wanted their gift used. And, again, you can work with the charity to try and ensure that whatever your thoughts are for the gift are fulfilled. A couple of words on asset protection. That's, again, one reason why we use trusts. When we talk about asset protection, we're trying to protect assets from, the phrase I like to use when I teach is creditors and predators. Creditors are just people that you either owe money to now or you may owe money to in the future. Predators are, if you've ever watched like American Greed or something like that, there are people that just, try and get other people's money inappropriately. One of the big things you need to be careful about doing any asset protection, there's something called the fraudulent conveyance rules. So if I have a creditor who has a judgment against me and then I take all my money and I put it offshore, I've probably violated the fraudulent conveyance rules, and that could have very significant consequences. If you're doing asset protection for others like children or grandchildren, well-constructed trusts are usually sufficient. And again, it's on your advisors to make sure it's a well-constructed trust. You want to weigh the benefits of putting flexibility into a trust to allow the beneficiaries to enjoy the property. You want to consider always using trust for minors. I'm a big believer in that in a will. And also, if you have a beneficiary who's under a disability, I will have clients who will have. I have one I'm thinking of right now. He has a niece who has been determined to be developmentally disabled. There's a guardian for her, and he wanted to leave her something, but we did it in something called a supplemental needs trust to make sure that the money would be available to her and not cost her potentially any benefit she might be entitled to from the state of New York. Asset protection for yourself is a little more complicated. Sometimes we use insurance. So where does this come in? Often this comes in with professionals. So I'll take myself as a lawyer. There are people that are worried about being sued for malpractice. Nice thing about teaching, my students can't sue me for malpractice, but doctors, lawyers tend to be worried about, the potential for large judgments against them. So the first thing is to use insurance. And if you think about it, I think we all do that, because if you have car insurance, if you have homeowners insurance, if you have renters insurance, it's a form of asset protection to try and protect your assets. Going past that, sometimes we use corporations and limited liability companies. If you think about it, if I own stock in Microsoft and Microsoft gets sued by somebody, they can't sue Marc Bekerman. They can't get money from Marc Bekerman, even if they are successful against Microsoft. Now, you might say, well, that's a publicly traded company. Well, if you do it correctly, that's true even for smaller entities. I have families that set up corporations and limited liability companies to run their, to hold their business interests. If you're using domestic trusts, meaning a trust that's established within the United States, that becomes complicated. If I create a trust in the state of New York and I am a beneficiary, even if it's discretionary and I'm not entitled to anything, that self-settled trust has no asset protection under New York law. Some states claim to have a different law. Delaware is one of them, for example. So the idea would be, well, can I move my assets to Delaware? And if I comply with Delaware law, can someone who gets a judgment against me in New York collect from my Delaware trust? Depending on who you ask. My friends who do asset protection say yes, and my friends that are more conservative like me ask about something called full faith and credit. Typically, the judgment in New York can be enforced in a sister state. I won't bore you all with the details on that, other than to say, until the Supreme Court of the United States rules on it, I'm going to say it's an open issue. And not that timing is everything, but I've got 12:59. So, Steve, I think I get points for just timing here.
That was nearly picture perfect as far as time management. And we can go a little bit over because we have two questions that we have just received from viewers, and there's one more that I know you and I talked about, just a small point to cover that probably would be a good way to wrap up the webinar. So I get to the first of the questions, and this one is a practitioner in one state, for example, New York, able to set up a will in any other state, for example, California, New Jersey, wherever?
So I'm going to give you a horrible answer. Technically, the answer is probably not, but I will say really it depends. I used to be very active with the American Bar Association. I have friends throughout the country. So sometimes they will be they are representing a family in, let's say, Georgia, and one of the members of the family now lives in New York, and they don't want to give up the New York person. So what they'll do is they will draft something, and then they will hire me to review the document to make sure it passes muster under New York law. So I would say you shouldn't be doing it. Your lawyer shouldn't be doing it so I'm admitted in New York, New Jersey, California. I only practice in New York. I will not write a Connecticut will. But if I wanted to, I would engage local counsel. I would get a lawyer in Connecticut to work with me. I've done this more with Florida than anywhere else because I have a lot of clients that kind of split their time between New York and Florida. So I have a lawyer in Florida who I work with that if I'm doing a Florida will, a trust for someone who's spending time in Florida, or a will, trust, whatever, I will, bring in my friend and he will consult with me. So I know that whatever I'm doing not only works under Florida law, but is the best thing to do under Florida law. But if you're going to do it without local counsel, the answer to that should be no.
The next question: if an estate does not have funds to pay a decedent's debts, is the family responsible?
It's a great question. Typically, the answer is no. First of all, the law has, it's called abatement, and it has a list of who has priority. So you've given to whatever the priority. Now there's more debts and no money left, or not enough money left. Different states have different law. I want to put that out there because I don't know what state may be implied here. In New York, usually, if the probate assets are insufficient, if the assets in the estate are insufficient to pay the debts, the beneficiaries of the estate are not liable. When could they be liable? They could, in theory, be liable if, let's say, the decedent made gifts to them right before they died. In other words, if those gifts would have violated those fraudulent conveyance laws that I mentioned earlier. They could be liable potentially if they got one of those non-probate assets, although New York, I don't think New York really allows it too much, but there are some jurisdictions that have some pretty detailed rules on being able to get it. And then, of course, you have what's the type of debt. If it's a tax debt, the federal government can go after anyone who inherits from the estate for a non-testamentary asset. So the general rule I would say is no, you're not responsible. But there are some exceptions to the general rule that if somebody claims to be an exception, you probably should engage local counsel to determine whether or not there really is liability on the individual. But I wouldn't just write the check.
Question that just came in: what document should be used to ensure my wishes for, quote, burial, recompose, human composting out of state? Sounds like it would not be the will from the information we got earlier.
And again, if you're in New York, I would say the appointment of agent to dispose of remains. If you're not in New York, I just don't know the laws in other jurisdictions. But in New York, I would use that appointment of agent to dispose of remains. And there's a part that says, specific instructions. And then I have clients who are very specific in the specific instructions, sometimes almost scarily so.
So we talked about a lot of important documents: will, power of attorney, healthcare proxy. I get everything written, signed, notarized the way I want. Where should I store these important pieces of paper?
So it's funny, that's been part of this week's lecture at the two schools for the basic class. So other than the will, I always tell clients, keep your own documents. I don't want your healthcare proxy in my office, in my safe, if I'm in Hawaii and somebody falls and breaks a hip. That's literally what happened. I always talked about it hypothetically. And a couple of years ago, I got to Hawaii and I had a message from a client that her 90-year-old mother had fallen, broken her hip, was at NYU Langone. They need the healthcare proxy. And I had to basically text her because it was the middle of the night here. I'm like, you have the healthcare proxy. I mean, we were able to resolve some stuff, but so my feeling is, other than the will, the client should hold on to everything. The will creates a little bit of a different discussion because if the original will is lost, it can be very difficult to get a court to accept a lost will. It's called probating a lost will. And you have to, among other things, prove that the will was not revoked by the decedent by destroying it. So there has to be some story. So if the attorney retains the will and loses it, then the decedent didn't destroy it. I mean, shame on the attorney for losing it. But if I give it to a client and we can't find it later, there's a presumption, it's a rebuttable presumption, but there is a presumption that the will was destroyed by the client with the intent to revoke it. So I usually tell clients it's up to them. I'm happy to hold your will. I'm happy for you to hold your will. If they choose to hold their will, I will just, give them the will, and that's that. If they want me to hold the will, I will give them a conformed copy of the will, not a second original, a conformed copy of the will, and I will write on the top original with Marc Bekerman. And so this way, whoever ends up finding this after the client dies knows to get in touch with me to get the original. The exception to that is if I have a situation where, let's say there were 3 children, and the will says 50% to child 1, 50% to child 2. I would suggest to the client that I should hold the original will and they keep a copy, because if child 3 finds the will after mom dies, child 3 might say, nope, never saw mom's will. So if I have a situation where I'm concerned that somebody who would have access, especially after the person dies, might find the will and do something dishonest, then I would suggest that I should hold the original will in that situation. But other than that, I leave it up to the clients. I know a lot of attorneys, their practice is to keep the original will. There are some complications that can come from that. And it's just, I don't know that there's a quote right answer. I always do whatever the client wants on the issue.
Marc, thank you very much for what was a very informative hour. And we had gotten a few comments that were sent to us that said thank you, it was great information, and they really appreciate everything that you shared. And so thank you so much for taking your time
before
to
you
share with us
dismiss
this
me, there was
afternoon.
one question that we postponed that I want to come back to. So
Yes, about how to find an estate planning attorney.
How
That's
do you get
correct.
an
So
estate planning attorney?
better memory than I had.
and I thought that would be a good way to wrap up the session. If you know an attorney and you like the attorney, trust the attorney, ask the attorney. You don't necessarily need an estate planning specialist. It depends on your particular facts and circumstances. Many people can be serviced perfectly well by a general practitioner attorney doing a will. If you don't have somebody, or if that's not going to work for whatever reason, there's a lot of ways you can find. So if you can't get a recommendation from an existing attorney, you can ask your friends if you're comfortable. Hey, did you ever do your wills? Did you like the person you use? Because, often I always say, the greatest compliment is a referral. So if you have a friend or family member that used an attorney and liked the attorney, it's worth speaking to them and see if there's a good fit. If you can't get a referral from your existing attorney or your friends and your family or stuff like that, pretty much every county has a bar association. You can certainly go to the county bar association and see, they may have a list, or they may have an estate planning committee that they can tell you who the members are. So I would start with that. If you've got significant assets and you really need someone sophisticated, there is the American College of Trust and Estate Counsel. It's called ACTEC. But again, that's really for high-end planning more than anything else. And if you're going to an ACTEC fellow, you can expect to pay a rate equivalent to their status, which scares some people away. But I would say always referrals are the best way to do it. Even if your lawyer isn't comfortable doing the will, they might say, look, I don't do wills, but I can give you some names of people who do. I don't do real estate. And so, like, when I have an estate that has to sell the house, I give my clients a couple of names if they ask for it, but like, I won't do the real estate. So in response to that early question, there are ways, but usually I go for referrals either from friends, family, or existing attorney. And again, if you have an accountant you work with, you can ask them, a financial advisor, an investment advisor, a life insurance person. Any of these people probably can give you some names. So pick who you trust the most, who you have the most confidence in, and see if they can give you some names. I always give 3 names because I always want clients to make, or they're not going to be my clients, I always want people to make an informed decision. So it's okay if somebody gives you 1 name, it's okay to keep looking until you have 2 or 3, if only because, how do you know that the price you're being quoted for the work is reasonable? You might think it's super high, you might think it's super low. So one way to find out is if you speak to 2 or 3 attorneys that are all in the same range. Okay, if someone is more expensive, it doesn't mean don't use them, but understand they're more expensive. Maybe there's a reason for that. And on the other hand, if someone's at $200 and everyone else is at $2,000, why is the person $200? Sometimes you do get what you pay for. So I just wanted to touch on that, Steve.
I definitely appreciate it, because that was one of the first questions we got, and we said, okay, let's save it for later. I was about to wrap us up and send us here, there, and everywhere. And then I'm glad you remembered that. So thank you. And once again, thank you so much for sharing your time and your expertise with us. Such a great friend of this university. And so it was a pleasure to bring you in and be part of this hour with you. And I hope you enjoyed it. It sounds like everybody else did too. So thank you again.
My pleasure, Steve. Thanks for having me.
I also want to offer my thanks to Jen Gabriel, who is behind the scenes helping to manage everything for today's webinar. So appreciate Jen's help as always. We have some great webinars. This was a great webinar today for sure. We have 2 others that'll be equally fabulous coming up in the next couple of weeks. The first of those will be February 22nd with Andy Wilner from the class of 92. Take control of your time. We all want to do more with the time that we have. We think we're great at multitasking, but we're not quite as good at it as we think we are. So that's what Andy will talk about and help us to be better at what it is that we're trying to do. So make sure you join us for that one. And then March 22nd, Jill Silverman from the class of 97 will talk about food addictions, treating obesity, focus on eating behaviors. I'll pull up the website address on the bottom of the screen, binghamton.edu/alumni, so you can find the links to register for those events. We are taking registrations for the February 22nd webinar. The March 22nd webinar probably will be opened up soon if it's not already. So definitely take a look at that. And always some great programming that's offered by the Alumni Association, whether it's the webinars, volunteer opportunities, or the real and virtual events. So check out our website when you can. And for Jen and Mark, I'm Steve Seepersod. Have a great rest of your day, and we'll see you at the next webinar.